The Constitutional Court will deliver judgment on whether the Western Cape High Court's order declaring the suspension of a public protector, Advocate Busisiwe Mkhwebane, invalid is subject to confirmation in terms of Section 172 of the Constitution. This comes after Mkhwebane claimed victory after she challenged a suspension from the Chapter 9 body in the Western Cape High Court in September last year. SABC News reporter Canny Maphanga joins us now in studio to talk more about this judgment that is expected to be handed down. Canny, thank you so much for making time for us. Of course, this has been a long one coming. We know various complaints that have been lodged against Advocate Busisiwe Mkhwebane. We saw some of the allegations also coming out of the Section 194 inquiry. But then eventually the president took the decision to suspend her in June. And the argument from the High Court, or the finding, was that the president acted unlawfully.
Well, good morning to you, Aldrin, and to the viewers at home. I think let's start from the beginning where this case emanates from. You may remember in June last year when the Phala saga became public, ATM leader Vuyo Zungula laid that complaint with the Chapter 9 body while Advocate Busisiwe Mkhwebane was still leading that Chapter 9 institution. She then sent the so-called 31 questions to the president to respond within 14 days from June 7. I think it was June 8th then that she was suspended by the president after announcing her decision to investigate the matter. She announced it publicly, you might remember that period. So it was a period of a few days from those so-called questions up until she was suspended. She then launched the challenge of her suspension in the Western Cape High Court. It then delivered judgment last year stating that if you look at the circumstances upon which she was suspended, the reasonable person would come to the conclusion that it was done perhaps out of retaliation and could be construed as an irrational decision on behalf of the president. And you may remember that before she could even make true on those words, that when she said she was going to return to the office following her victory, the Democratic Alliance had already made the intention to appeal that judgment quite public within minutes of it being delivered in the Western Cape High Court. So that's what brings us here at the Constitutional Court now. Last year, the hearing did take place where the DA challenged the Western Cape High Court judgment, saying that it erred in its judgment. We remember some of those arguments that they made in the court, saying that even if there is a scenario where the Western Cape High Court was correct in its judgment, they were of the belief that the public protector should not be able to return to the Chapter 9 institution, and that the remedy that should follow is that that process should be done again in a fair manner, and the president should be given a chance to make that decision in a constitutionally fair process. So that's what brings us here today. We're going to find out from the Constitutional Court whether that judgment was correct or not.
Yeah. And does the Democratic Alliance or even the president say in that with regards to that if the court finds that the process should start again, who should be the person then who makes the final decision? Because now, of course, the public protector's office is done with the Phala investigation. But then on the other hand, the Western Cape High Court has found that the Constitution actually does provide remedies should the president be conflicted.
Yes, that was a big argument during the hearing in the Constitutional Court, that should this process be unfair or they confirm that the suspension was invalid, then who should carry out that decision? And I think the Constitutional Court needs to spell it out, because we also have this interpretation that once a High Court order rules against the conduct of a president, it needs to be confirmed by the Constitutional Court in terms of Section 172 of the Constitution. So the Constitutional Court in its judgment needs to spell out all of these issues and really explain to the public how it'll reach its conclusion. Yeah, it
actually reminds me of one of the other High Court judgments that was handed down during the time of former President Jacob Zuma with the NDPP, Sean Abrams, and there the court found that because the president is conflicted, it should be the deputy president who makes the decision around the appointment of the NDPP. But then a final one is around the public protector herself. We know that the president had made his intentions to suspend her clear by March already last year, although the decision to suspend her only came in June. Was the question around the public protector's own conflict raised at all, or that the public protector acted in a malice way in how she sent those questions to the president?
I think the central theme was whether the president was conflicted at the time he made the decision to suspend. And if you look at it in that close period of June, perhaps you would have reached the conclusion that the Western Cape High Court reached on the matter. However, the President's lawyers during that case did explain that that process started long before June, and that the President had given the Public Protector at the time multiple opportunities to give representations on why she should not be suspended. And then I think because those events happened in close proximity in June, that led to the suspension, and then Advocate Mkhwebane was able to challenge that. I think, but this will all be ventilated in that Apex Court's judgment that will be delivered at 10 a.m. virtually, and we'll get a better understanding of whether the Western Cape High Court was correct in its interpretations and its findings, or whether the suspension was actually lawful and valid. But remember, her term does end in October, so I don't know what effect, if she is successful in this application, that will have on the Chapter 9 body. As you've seen, the nominations process has already started, and they're already looking to fill that position. So I'm not sure if there'll be any merit or advantage in returning to that office for the next few months up until October, when the term ends.
Yeah, and Advocate Busisiwe Mkhwebane has already indicated that she believes that this judgment becomes academic. She said in one of her tweets in response to the ATM's challenge to the JSC that thanks for the intervention. As I said, this judgment will have to be sent to law students as part of research on justice delayed is justice denied. The DA and the President told the ConCourt that I must not touch the Pata investigation so that the DPP can conduct it. That has now been achieved, and congratulations to them. But let's see how this one is going to play out just after 10 o'clock. Canny Maphanga there, SABC News reported. The judgment will be handed down virtually at around 10 o'clock, and we will be taking it live here on the agenda. So stay tuned for